Hey everyone. I guess somebody copyright strikes me. I don't know. But I think we're back now. So I just wanted to point out that the prosecutor's fallacy makes the statistics that Bill Thompson used most likely inaccurate. So it confuses two separate equations. So is it working? Okay, I think it's working again. Okay, I think it's working again. Perfect. Okay, so they gave me, maybe it was the guy that I was playing. Let's see if I can do this one.
In this example, suppose that a defendant is charged with raping a victim. So here's our prosecution hypothesis that the defense raped the victim. And the evidence we've got is that a tiny trace of DNA which matches the defendant was found on the victim. And the prosecution could argue that if the hypothesis was true, then we'd certainly get the DNA match. And if it was false, there's a 1 in 100 chance that we'll get the DNA match because this is a profile that you'd find in 1 in 100 people. It's the kind of random match probability you'd get where the tiny trace only identified, say, 2 loci. When we enter the observation that the evidence is true and run the model, we get the posterior probability heavily in favor of the prosecution hypothesis. In fact, the likelihood ratio here is simply the posterior probability of true divided by the posterior probability of false, because in this case, the priors were 50-50, and so the likelihood ratio is just equal to that ratio. The problem here, and it's fairly typical of the use of the likelihood ratio, is that we've got some fairly complex evidence here, and we've lumped it together into a single piece of evidence, a single evidence proposition, if you like. And that doesn't properly reflect the nature of this evidence. And it also makes the mistake of assuming that the DNA match relates to the hypothesis that the defendant raped the victim rather than the defendant being the source of the DNA. A much more appropriate model is this one. First of all, note that the evidence that the DNA found on the victim matches the defendant relates directly to the hypothesis that the defendant is the source of the DNA found on the victim. And that's different from the hypothesis that the defendant raped the victim. Obviously, the defendant raped the victim, then it's much more likely that the defendant is the source of DNA found on the victim, but these are different. So if we look in here, how that's defined, that's exactly how the DNA match evidence was defined before, but this time it's really correct because that is the random match probability associated with a person other than the defendant being the source of that DNA. If we look at the probability the defendant is the source of the DNA found on the victim conditioned on the defendant raped the victim, then this is fairly uncontroversial. If the defendant raped the victim, we'd certainly expect very, very likely that the defendant is the source of the DNA found on the victim. But there's also, let's say, a 20% probability because of secondary transfer and other explanations of why the defendant's DNA could be on the victim. But the most critical change is the introduction of this separate evidence component, which is the fact that it was only a tiny trace of DNA found on the victim. And the critical part here is that if the defendant raped the victim, and if the defendant is the source of the DNA found on the victim, then it's very unlikely that we'd only find a tiny DNA trace. We'd expect to find lots of DNA in that case. And if the defendant is the source of DNA found on the victim, and the defendant didn't rape the victim, then it's much more likely that we'd find only a tiny DNA trace on the victim. Now, when we enter the DNA match evidence, then as expected, that significantly supports the hypothesis that the defendant is the source of the DNA found on the victim, but it doesn't support so strongly the hypothesis that the defendant raped the victim. It is probative in favour of that, but nothing like as probative as it is in favour of the defendant being the source of the DNA found on the victim. Moreover, if we now enter the extra evidence that it was only a tiny trace of DNA, then look what happens here. Whereas we're still fairly sure that the DNA found on the victim does belong to the defendant, we're no longer sure that the defendant raped the victim. In fact, that probability is now less than the prior probability. So the likelihood ratio of this combined evidence is this divided by this, which is less than 1. So this combined evidence supports the defense hypothesis rather than the prosecution hypothesis.
Okay, so now that we have watched a few videos on the prosecutor's fallacy, I hope it's starting to come together now what that is. And I think that it's related to the other things that are happening, like the tunnel vision, the rush to judgment. All of these things are a product of the environment that MPD and Bill Thompson were in. I did want to show one last video, but I wonder if that guy copy struck me. Let's see. Because on the last video that I had of that guy, he was saying that police have the same patterns. And if the police keep investigating within these same patterns, then we're going to keep getting the same types of wrongful convictions. If they keep using the same type of flawed statistics, or if they keep using statistics that the jury doesn't understand, then we're going to have these issues over and over again. I wonder why that said it would give me a copyright strike. Oh, no, not this one. So it's this one. Maybe he'll let me play the very last bit and not all of it.
Brown spent the years following her release working as an assistant to a county official before founding an organization to assist the incarcerated. She had and will continue to be destroyed because we keep getting the same things wrong.
There we go.
We fall prey to the same cognitive biases, analytical fallacies, and just plain thinking errors that I've been exploring on this channel for years. One day it's the Einstein effect, the next day it's confirmation bias, or any of dozens of misinterpretations in math. I know all of these things. You know all of these things, but not everyone else does. And their compounding errors can determine the freedom of people named, well, whatever your first, middle, and last name is. And as always, thanks for watching.
So I think that's really interesting that he said that we keep making the same mistakes. So the same things keep happening. And here is Becca Barlow's declaration, where she mentions that the prosecution does use the prosecutor's fallacy. I'll show you down here. So that what Vsauce said is so true. I think that they need to stay away from using these likelihood ratios or things that are just confusing for the jury. Like, it might make sense in the science world, but how is the fact finder, a jury of your peers, supposed to understand something that is so technical? And we are stuck in this same pattern of the wrongfully convicted. Luckily, there are things like the Innocence Project or the civil rights group, that what is it, NCAA, or things like that. But I think it would also help if we stop using things like that, or still use it, but make sure that we have terms and firm definitions that the average person can understand. Otherwise, tragedies like that Sally Clark case that we were listening to earlier? Yeah. So here it is. So at the bottom down here, it is in a footnote. Did I pass it? Right here, at the bottom of page 9, in the Declaration of Becca Barlow, it says, in this motion, the government misstates the statistical rarity of the comparison to the DNA from the sheath on page 6. The STR profile is at least 5.37 octillion times more likely to be seen if defendant is the source than if an unrelated individual randomly selected from the general population is the source. This reported statistic for this comparison is a likelihood ratio similar to the RMP, which is the random mixture profile. I don't know, don't quote me on that one, which compares two competing hypotheses. The government statement is extremely misleading and is essentially the prosecutor's fallacy. So we just learned about that. So the prosecutor's fallacy is that there's two different statistics that are being confused as one. And when that happens, that usually means one of them is wrong. And in this case, the DNA experts are saying, Bill Thompson, your statistic is wrong. The fallacy is to say that the probability is also the probability that the DNA at the crime scene came from someone other than the defendant. Wait a minute. It does not say the odds that the suspect contributed the evidence are 1,000 to 1. Wait a minute. The fallacy is to say that the probability is also the probability that the DNA at the crime scene came from someone other than the defendant. Does that make sense? So is Bill Thompson saying, yeah, they have his DNA because they have his DNA, but the probability that someone else has Brian Koberger's DNA, that's different. The probability that someone else has Brian Koberger's DNA is not the same thing as saying DNA was found on a knife sheath. So I don't know if you've been following Kuhar Luker, I think that's how you pronounce it. She has been going through the BS, and Bill Thompson is very good at this. And if you see here that this the motion for protection order for the IGG, it's written in a way that's very confusing, very similar to how the PCA is written. These things are what Bill Thompson does. He'll BS to the end of time. And I think that's what he's done here with this case, because like, as we know, the evidence just isn't there, but he's been able to spin it where it may not be actual like lie, but what he's talking about is something different here. Does that really say that this statistic means the DNA at the crime scene? Wait. Yeah. What are the odds that someone else has Brian's exact DNA? Oh, hello, Twizzle Stick. Welcome back. I don't know what happened there. Yeah. So, do you think that guy copy striked me? I didn't mean to do that. I wanted to share his knowledge. I thought he presented the dumbest math in like the funniest way. So, I'm also reading the bottom of page 9 of Bishop Barlow's declaration, and she's talking about the prosecutor's fallacy here. And we were just learning about that, where the prosecutor's fallacy is confusing two different types of statistical equations. And they measure two different things. So I'm reading this again, and Bishop Barlow is saying the fallacy. Oh, okay. Thank you for that. I could just stop it and it should come back on. Good. Thank you. I'm new at this. So the fallacy is to say that the probability is also the probability that the DNA at the crime scene came from someone other than the defendant. So is Bill Thompson saying it's 5.3 times probably that someone else has Brian's exact DNA? It doesn't really say that that was the DNA found at the crime scene. What that's saying is it's going to take a lot for someone to have his exact DNA. But this is what Bill Thompson does. This is how he like spins stuff. He makes things so confusing so that nobody can really understand what's going on. He's handcrafted this case like nothing other than I've ever seen. And which this could be true, because I don't necessarily think the IgG was completed. And I think because of the way that the cell phone data that Cy-Ray was saying, look, I don't have the source information. No matter which expert you get, they need the same information to be able to confirm that alleged route, I guess, in the second AT&T warrant is actually accurate. And then Cy-Ray listed out some things that you need specifically to make those claims, and those claims and those things were not used at all. I think Payne didn't understand whatever DNA expert they used said either. Exactly. Payne didn't understand what was going on at all. And so, since Payne doesn't understand how to confirm a route, he didn't use any or retain any of the source data required to make statements like that. I believe, in the same vein, whatever happened to the IgG, it's not completed. Like, and Taylor is getting together a team of experts so they can see exactly what happened. And hopefully they tell us, look, this is not how you do it, because this is how you do it. And this is just not adding up. And from the way that the PCA is written and the way that the motion for protective order is written, you know those things aren't straightforward. And so if you apply that principle to how evidence is gathered or statistics are used, Bill Thompson, he is very good at BSing his way through this entire case. And so if somebody is calling him out for the prosecutor's fallacy, like, I don't think they just do that. I think that the only way that Aunt Taylor would allow this to happen is if she can prove it, because she's in this position where she knows Bill Thompson's tricks. She knows how he works. So she is going to be very strategic in how she mentions things. So she's not going to just throw that out there. And I do think that this is curious, the way that Becca Barlow words this. The probability is the probability that the DNA at the crime scene came from someone other than the defendant. Yeah, so he's confusing two different statistics there. And so I think that's really interesting. It's just plain wrong. And I don't think Bill Thompson has ever been called out on his BS. I think he's about to be. Yeah, Taylor's coming for you. But yeah, so the prosecutor's fallacy is an important thing because it happens. And there's lots of studies behind why it happens, how it happens. As you can see, I had a whole list of those videos there. So there, if you just type in the prosecutor's fallacy in your YouTube search bar, you're going to get plenty of videos. Granted, a lot of them are they can be boring. But I found that other guy, Vsauce, he makes things kind of fun. And his videos are entertaining. And I started on Twitter by trying to give everybody information and resources so they can teach themselves about DNA, because the DNA, if they actually have it, which I don't know if they necessarily do, it is the weakest type of DNA you can have. And if you notice, the prosecution, the mainstream media, they have never said what type of DNA they have, because I don't think they're going to admit they have the weakest, most unreliable DNA there is. We did hear that from Blum, but again, we don't know if that's true. And also, Ann Taylor put, I think, touch DNA in one of her motions. So she has confirmed it is. And also Mercer, when at that, was that another motion to compel hearing, that DNA hearing? He had also described it as eDNA, which is environmental DNA. The partial and ambiguous sample, that's right. Right. So but yeah, both of those terms, all the terms you just said right there, Twizzle, partial, ambiguous, and touch, that all means it is trace. It all means it's the weakest kind. And I've been thinking about this lately too. Anytime you look or think about or try to talk about the DNA or the sheath, there's something wrong with it. Because if what we're hearing is true, that there were 2 victims in the close vicinity to the sheath, and they were in an altercation with the perp, there should be at least 3 DNA profiles on that sheath. There should be the 2 victims and the perpetrators. But there's not. And I know people out there have said, oh, well, they wiped it down. Well, if they wiped it down, there should be evidence of bleach residue or the fibers from whatever material whoever used to wipe it off. However, the way that the police and the PCA describe the sheath is, well, yeah, definitely. And I don't think we actually know what the weapon was. But they describe it as if it's a brand new sheath. It's pristine. And I think maybe that's why the defense said it was placed, because if there isn't any fluid on it whatsoever, I think it's highly likely it wasn't there during the altercations. Then you have to ask, where was it? Why is it not congruent with the environment, with what was there? If it was, it would be covered in bodily fluid. So that's that. And so then we're told it's a single source, male DNA source. However, they can say that if they did the deconvolution process, where they take the 2 known DNA profiles and they take those out, and then what you have left would be the unknown DNA profile. However, they're saying, they make it sound like, oh, this brand new clean sheath that has 20 dead skin cells on it, it's perfectly clean and placed right in the vicinity of 2 bodies, just waiting for Moscow police to come and find it. Like, so that's an issue there. And 2, the low copy DNA, which is the trace amounts of DNA, which sometimes with amplification, we can't always see it. There's the drop in of the alleles and the drop out. There's stutter effects. And a lot of times you can tell if it's a mixture. 19 picograms. Wait a minute. Aren't you supposed to have 100? I didn't hear that. I thought, no, you're right. Well, I thought I heard 20. But yeah. So yeah, I did hear something that low. And when it's that low, there's no way it's accurate because of the drop in and the drop out of the alleles. So I was saying this, I think, in my previous video, that 750. Yeah, see, Bill Thompson, this is his doing. It's his writing style. And I wonder how long he's been like that. Because if he's been this way, like, how many other people did he just, like, set up? I mean, like, eyes aren't just on America. The world is watching right now, and we're all confused. So there's something in that DNA, because at any angle there's an issue with it, because it should have been a mixture. There should have been more. Yeah. Yes, every case. Oh. Let me show you what I posted on Twitter today. I post it monthly, or not monthly. There's my profile. I'm usually on my phone, so I don't know. See, look, they censored me right here. But there is an article called A Rogue Prosecutor. The Rogue Prosecutor's last case. I've posted it since, I don't know, a year. This is going to be Bill Thompson. Here we go. Lasting damage. A rogue prosecutor's last case. Claude Stewart. Stewart had told the court a flat-out lie, she said, because he was afraid the witness's testimony would undermine his case, or that Rios would decide Stewart had withheld potentially exculpatory evidence. So there are cases where prosecutors are disciplined for their actions. Oh, Misty's in the house. Hello and welcome. I think so too. I think Bill Thompson has a lot to do with this setup. Oh, it's so good to see you, Misty. So, Claude Stewart, after a career full of trouble as a prosecutor in Queens, finally went too far when he lied to a judge in effort to convict a man of murder. Oh, the parallels. It's just here, out of order. So, among the thousands of prosecutors who have tried cases in the name of the people of New York City, Claude Stewart came to hold a handful of unfortunate distinctions. He was a serial abuser of his authority. State appellate courts reversed 3 convictions based on his wrongdoing. His misconduct actually led to disciplinary action by his superiors. He lost his job and eventually his law license after an appellate court determined he had lied to a judge about the whereabouts of a key witness. The particulars of his disciplinary proceedings became public, opening a window into the typically secretive panels that are supposed to police the state's lawyers. Stewart declined repeated requests for comment for this story. It's worth it then to appreciate the impact of Stewart's career in greater detail, how the misconduct took place, how it has complicated the continuing pursuit of justice, and how the consequences of Stewart's misconduct still linger years after the man himself was exposed and disgraced. And the People v. Tyrone Johnson. Stewart's last trial as a prosecutor in Queens is a case to trace those issues. So on February 24, 2000, Queens prosecutor charged 23-year-old Tyrone Johnson with the murder of Leroy Van. 3 weeks earlier, Van, an owner of a nightclub that Johnson frequented in Jamaica, Queens, had been shot in the stomach at 3:20 a.m. while standing in front of his home. Van stumbled inside, tumbled behind a couch, and called for his elderly mother, Mary Poirier. His mother later testified that Van had told her that a man named Tyrone from a nearby housing project had shot him in a botched robbery attempt with at least one other man, according to court records. Police officer John Blandino said he interviewed Van as an ambulance sped them to the local hospital. Leroy, listen here, you have a big hole in your chest, Blandino said, according to court testimony. There's a chance you may not make it, but let's catch this person that did this to you. Tell me about Tyrone. Vaughn coughed, sputtering blood, repeated what he told his mother, and then added Tyrone drove a white Lincoln Navigator, according to the officer. When Johnson was questioned that morning, he volunteered to go to the precinct for questioning and told the police he wouldn't shoot Leroy, his friend, according to court records. He was released after police interrogated him for several hours. 2 weeks later, Daniel Small, a man in a police custody for a separate offense, identified Johnson in a photo array, saying he confessed the crime to him. Johnson maintains what he asserted at the time: he played no role in the killing. The trial. By the time pre-trial proceedings began in spring of 2002, Small had died. Stewart, lacking any physical evidence, does that sound familiar, told the court and Johnson's defense lawyer that he would rely chiefly on the testimony of Blandino and Poirier to make his case. Sounds like the Koberger case. Bill Thompson's going to rely on whoever he got off the street to say whatever. But the day before trial, Stewart dropped what amounted to a bomb, telling the defense he intended to present a third witness, a 22-year-old man named Henry Hanley, who lived across the street from Van and had fled when police first tried to interview him days after the murder. Henley was arrested in March 2000 on a probation violation and questioned about the murder. He said he was paid to be a lookout while Johnson and another man murdered Van in an attempt to rob him. He agreed to testify against Johnson in exchange for a light sentence for his involvement. So does that mean he's an informant? Hanley wasn't Stewart's only late surprise. He also waited until just before trial to share with Johnson's lawyer a potentially critical piece of evidence: the police statement of Shanice Knight, a relative of Henley's. Knight had told investigators that she had seen a man confront Van minutes before the shooting. She described the man as about 35 years old, 6 feet tall, 230 pounds. Johnson was 23, 5'6", and had a much slighter build, weighing about 140 pounds. Knight had not identified Johnson when she was shown a photo array of possible suspects that included his picture. Johnson's lawyer understandably wanted to call Knight as a witness, but he could not locate her. He asked Stewart repeatedly during the trial if he knew where she was. Stewart said he didn't. Court records show that on June 4th, 2002, Judge Jamie Rios, who was overseeing the trial, also asked Stewart if he knew where Knight was. Stewart said again he didn't, adding that he too was trying to find her. Johnson was convicted the next day of second-degree murder. He was sentenced to 20 years to life. In an interview at Sing Sing Correctional Facility, Johnson's face was grim when he recalled hearing the verdict read. I felt broken inside. Ugh. So then here's the reversal after all that. They do. I hope that there can be like civil charges brought against Payne and Bill Thompson. Oh, they did on Rogan. Okay. The reversal. The verdict was only hours old when Johnson's family and lawyers set about mounting an appeal. It didn't take long for that effort to provide a shocking revelation. Michael Race, a private investigator hired by the family, tracked down Knight. Knight, for the first time, told her story to Johnson's side, and there was much more to it than she had initially told police. Knight said she could discredit Henley's critical testimony. She told Johnson's investigator that Henley had been neither an accomplice to the crime nor a witness to it. She said he had been staying with her and was downstairs asleep when the shooting occurred. Knight said she woke him when she heard the gunshots. She ultimately signed an affidavit to that effect, but she had one more explosive bit of information. She said in her sworn statement that Stewart not only had known where she was during the trial, but that she and 2 police detectives had visited her at her job just days before Stewart had insisted to Judge Rios that he did not know where she was. More of Stewart's case soon seemed to crumble as well when Race went to Henley in prison. Henley signed an affidavit in which he recanted his testimony and alleged that he was pressured by Stewart to accuse Johnson. I did not witness this incident into the death of Leroy Van, Henley's affidavit said. I want the court to know and understand what I had previously done was a great error. A television station aired an interview at night in which she described her meeting with Stewart. The segment also featured Henley's girlfriend, Charmaine Remdes, who confirmed that she and Henley were asleep at the time of the murder. Later that year, Stewart's supervisors agreed to have Johnson's conviction vacated. Queens District Attorney Richard Brown wrote a letter to George Rios saying as much, adding that Stewart's conduct could not be condoned. The disciplinary process. It is impossible to know how many prosecutors get reported to the state's disciplinary panels for alleged misconduct. What is clear is that the appellate judges who overturn convictions because of misconduct don't routinely refer to offending prosecutors to the disciplinary committees. Defense lawyers, for their part, are often reluctant to complain formally, fearful that they will incur the wrath of a prosecutors they will have to deal with again and again. But Stewart's conduct in the Johnson case did provoke a referral. A trial judge, after vacating the conviction, sent District Attorney Brown's letter to the disciplinary panel known formally as the Second Department Grievance Committee. Brown had been blunt in his letter. He said, Stewart's handling of the Johnson case was totally inconsistent with the high ethical standards that I expect from my assistants, and that this office would pressure an investigation or pursue an investigation. If disciplinary action against the assistant is appropriate, it will be taken. Brown did act against Stewart, forcing his resignation. When investigators with the disciplinary panel began to dig into Stewart's record, they found that he had actually been reprimanded years before for another flawed prosecution. In 1995, Stewart insinuated that a gun in the possession of the defendant at the time of his arrest was the same gun in an attempted murder and robbery. But Stewart had a ballistics report showing that wasn't true. Bullet casings found at the scene of the crime didn't match the gun. The defendant, Jay Walters, was convicted and sentenced to up to 25 years in prison. He served nearly 4 years before his conviction was overturned by an appellate court, which found that Stewart advocated a position which he knew to be false. Do you think Bill Thompson knows his case is false? Anyway, which found a position he knew to be false, an abrogation of his responsibility as a prosecutor. The investigation of the 1995 case ended with disciplinary panel issuing Stewart a so-called letter of caution, warning him not to breach ethical boundaries again. It was never made public. Stewart's bosses in the Queens District Attorney's Office say that they did not know about it. I'm sure if this ever happened to Bill Thompson, he would know who to talk to keep that quiet. Oh, yeah, that reminds me, Twizzle, if you're still in here, you used to have a picture on your YouTube, and I thought it was you, with like Brian and Ann Taylor and everyone. That's pretty awesome if you have a pic of all of them. That's cool. Yeah, I do wonder if Bill Thompson has any of this. He is a person who would know how to hide it. So years later, when the panel looking into Johnson's case asked about the Walters matter, Stewart blamed his misconduct on inexperience. He then asserted that in the Johnson case, while he should have acknowledged seeing the key missing witness, he did not intend to mislead the court. I certainly made an error or mistake in judgment, he said. He claimed that he had telephone night the day before he was asked about her whereabouts by Judge Royce, but that he had not reached her. He said he based his reply to the judge solely on that. I answered the question very narrowly, he said. Melissa Broder, counsel for the disciplinary committee, dismissed Stewart's explanation. Stewart had told the court a flat-out lie, she said, because he was afraid the witness's testimony would undermine his case or that Rios would decide Stewart had withheld potentially exculpatory evidence. In September 2005, more than 18 months after it had opened its investigation of Stewart, the committee suspended Stewart's license to practice law. After his resignations, he landed a job in a private practice doing civil litigation, a job he then lost along with his license. I was disappointed that I had to let him go, said David Brand, a partner at the Long Island firm Stewart had joined. He was actually good, effective lawyer. In March 2010, New York's Appellate Court Division denied Stewart's application to renew his law license. Good. Saying he does not demonstrate the requisite fitness and character to practice law. Stewart, who still has an active license to practice law in New Jersey, today works as a math teacher at Queens Vocational and Technical High School. Johnson, who remains to this day in the prison cell, in part because Stewart said he feels sorry for the former prosecutor. I wish he just learned a lesson, but he didn't have to pay for it with his whole career, Johnson said of the severity of Stewart's discipline. You're held to a high standard. Don't set people up. If there is evidence of someone's innocence, explore it. They know when something is not right. I'm sure Misty knows I tweet this article every so often. I think it's fitting for the situation. The retrial. Eugene Ripstein, a high-level Queens district attorney who had tried dozens of homicides and felonies, was tasked with mounting the second prosecution of Johnson in 2003. Ripstein visited Henley in prison and got him to recant his recantation, despite his sworn affidavit claiming he lied at the first trial. Henley told the same story during the second trial. This time, however, Johnson's lawyer got to put Knight on the stand. She testified that Johnson couldn't have been responsible for the crime because he was far smaller than the man she saw that night. She also stuck to her earlier sworn statements that Henley, the alleged eyewitness, had been asleep in her apartment at the time of the shooting. Ramdas Henley's girlfriend and that time testified that she was in fact asleep with Henley during the shooting. It was not enough, Epstein said that Knight and Ramdas were lying in his summation, but ultimately it was Van's mother, Mary Puryear, who shifted the balance of trial. A New York Daily News story described the jury as transfixed when Puryear, Van's mother, testified from a wheelchair and tearfully describing how Van told her, "Mama, I've been shot. Tyrone did it." Johnson was convicted again and sentenced to 20 years to life. The controversy around the case did not end there. After the trial, Judge Rios' law clerk wrote a letter to the New York State Commission Judicial Conduct accusing him of coaching the prosecution in private discussions during the second trial. Whoa. Johnson's lawyers petitioned for yet another trial at a hearing. Rios admitted to speaking to Epstein in his chambers, but said he could not remember the details of the conversation. Brooklyn Supreme Court Judge Matthew D. Emick ruled that while the conversation strayed into improper territory, it did not prejudice the verdict against Johnson. Now 36, Johnson spent the last 13 years behind bars. His lawyers maintain he never received a fair trial, and they have now applied to a federal court to grant him yet one more trial. It doesn't get easier, Johnson said in an interview at Sing Sing last year. You see your mom get old, you see your children get older, relationships fall apart, people die, it gets harder as you go along. My son was 5 years old when I got locked up. My son is 17 on Friday. He is eligible for parole. Johnson's soonest possible release date will be in 2020, but to qualify, inmates usually have to express remorse for their crimes. He says he'll never do that. He'll never admit to something. I'll never admit to something I didn't have anything to do with. There you go. The last case of a rogue prosecutor. I don't know if we'll be seeing mirrored events or not. You are in it, Twiz. I know. That is so funny. Like, I can't see your face, but, I can see the people in front of you. But I thought that was you. Okay. Right. Well, hopefully she can, lay it out for the jury. I still, I hope that do we even know if the DNA evidence is going to be admissible? I guess we don't even know that yet. Especially if, the DNA isn't really Brian's. So here's something really cool. I've also posted this on Twitter. This is NIST. If you saw some of my other videos, I talked about NIST before. Yeah, okay, right, because if they can definitely prove that arrest warrant, because Payne didn't have any of the information that is required to get that second AT&T warrant. So I'm very interested to see how the motions to suppress are going to go. But it's felt like there's been like a lull, like the calm before the storm. But once those motions to suppress start flying, I think things are going to get fast very quickly. No, the cell data should not have been used. It doesn't sound like they had any legitimate cell phone information. Remember way back, BK said, "That's not mine." He did? I don't remember that. Did his Pennsylvania attorney say that? Or was that something like the news was saying, like in the beginning? Because even in the beginning, I heard the news say they found the sheath outside near the dumpster. And then all of a sudden, the next time we hear of it, it's in bed with Maddie. So some of those things early on could be actually truthful. I don't know, though. Well, I used to joke that Payne literally used Google and like printed out a map of a possible way he could have gone. Yeah, he wouldn't have known about it. So when there was another thing that I wrote about on Twitter, because if you count the number of times Payne references like a cell phone or like body cam of the sheriff, it's about 12 times. And so there are some dates that aren't, the 24-hour, the first warrant, which is the 24-hour warrant, which is the 24 hours before the incident and 24 hours afterward. So if that was the only warrant that he had, he couldn't have known the other stuff. And even if he did get information back from that second warrant, it doesn't seem like it was useful, because everything in that PCA can either be explained away by a camera, a body camera, because wasn't he pulled over in Moscow by that sheriff? So if he was pulled over or in Idaho by that sheriff, you can assume his phone is pinging on a tower in Moscow because of his location of where he and the officer are. And there's also times where he's driving past the coffee shop, right, in the PCA, and he's on WSU campus. But those are all cameras. But Payne does a job of kind of confusing, is it a camera that's locating the location, or is it actual cell phone records? But if you break it down and make a list of all of the locations and times, it can be explained away by either a camera, and 90% of them are in Pullman. So like, I'm wondering if he actually got any information back in the second one. That's good to know, Misty. I didn't know that. I'm beginning to think that it isn't, because of how they're describing it. Because they can't really come out and say some things. They didn't have pings, though. They just see what tower he connected to when his phone. Okay, yeah. Yeah, they didn't have any pings. That's really cool. So this is from NIST. I did some articles on it. It's the National Institute of Standards and Technology. And this talks about DNA mixtures and trace DNA. So the methods have become so sensitive, forensic scientists once needed a relatively large amount of material, such as blood or a semen stain, to produce DNA profile. Today, they can generate it with just a few skin cells that are left behind when touching an object. You don't necessarily have to touch it. DNA can travel in the air now, too. This capability is an incredible technological achievement. It is also a positive development because it allows forensic science to help solve greater variety of crimes. Investigators might be able to solve a sexual assault, for instance, even if very little DNA were recovered. They might investigate a break-in by swabbing the pry bar that was used to force a door, or they may swab a firearm that was used to commit a crime. But such high sensitivity is a double-edged sword. We often shed small amounts of DNA when we talk, sneeze, or touch things. As a result, many surfaces are likely to contain mixtures of minute amounts of DNA from several people. These mixtures have always been present at crime scenes, but when sensitivity was lower, they wouldn't have been detected, or if they were labs would not have attempted to interpret them. That's no longer the case. So this is with low sensitivity, and you have these different colors here to show, where the DNA, lots of it are on touch surfaces where we put our arms or our hands. We open doors. We might put our hands on the table or the chair rail to stand up or sit down, and they're on these handles as well. But then when you do the high sensitivity stuff, look how much more. But again, if a crime happened in here, there's no context for the differences of these DNA's profiles. So, wow. There's a lot that goes on the handle of the refrigerator and the freezer. So, like, being able to see this much more DNA, how helpful is it? Right, Misty? Like, he knew them, like, right away. Right. It can be transferred from someone who's never been in there. Yep. Okay. So by looking at these, they are different. But like in statistical realms, I wonder how close these would be and how confusing that would be to hear from an expert, a forensic scientist, explaining the likelihood ratio. I'm sure that this reference profile has a likelihood statistic that is confusing for a jury. And even though these are different, they're not the same. Like, a forensic scientist is going to go up there and say, yeah, it's likely that these things are similar. But the prosecutor always just wants to know, is it the guy or not? But that's not necessarily how these likelihood ratios work. And that's not always explained to the juror. So a profile of a low-level DNA mixture from a crime scene is up top, the evidence profile. And the DNA profile taken from a suspect when the peaks in the evidence profile are small, they can introduce uncertainty. Did a false peak drop in at position A? Right here. Did a peak drop out at position B? To avoid prejudicing the evidence, the determinations are made before looking at the reference profile. And I know that they also have like error statistics, room for error, so they kind of calculate in their rates of drop in and drop out. But still, there's what I'm looking at is an image. If I were to see that in a courtroom, I couldn't convict a guy. Okay, these are my favorite explanations. So in this case, we can assume the number of peaks that evidence contains DNA from more than one person. The peaks are small because the amount of DNA is low. Interpreting these profiles involves at least two uncertainties. So, uncertainty number one, when is a peak a peak? When the amount of DNA is very low, the peaks can be very small. Some peaks can also be that they disappear entirely. They call that dropout. Also, small blips in the data can be mistaken for real peaks, and they call that drop in. Many of these effects are random, and they can make it difficult to interpret the evidence. Uncertainty number two. Whose peak is it anyway? When analyzing a DNA mixture, the alleles from all the contributors show up on a chart. These can make it difficult to tease apart the DNA profiles of individual contributors. To understand why this makes things complicated, recall that amplifying the DNA for forensic scientists has a test tube with millions of copies of alleles in it in solution. Think of a test tube as a bowl of alphabet soup. This is a really awesome example. I'm sure, Missy, you've seen me post this, I don't know how many times on Twitter, but it's my favorite, so I post it a lot. So where did I go? Right here. In this bowl of soup, each letter represents a different type of allele. Our suspect is named John Q. Suspect. So these are going to be all the alleles in the test tube that the scientist has. And so they're going to pick out the alleles or the DNA profile. Right now, our DNA profile shows as John Q. suspect. We analyze the soup to find that all the letters in the suspect's name are present. Does that mean someone named John Q. suspect contributed to the soup? Not necessarily. There could have been 2 contributors named Patrick Queen or Justin Orr. In that case, the soup would have all the letters needed to spell John Q. suspect, even though no person with that name contributed to the soup. So with the same numbers here, the same letters, you can get these letters. So in the test tubes with the alleles, the DNA mixture, there could be DNA profiles present that could be similar to yours or mine, but we were never at the scene. So this illustrates an important point about DNA mixtures. Just because a person's alleles appear in a mixture does not mean that person contributed to it. The alleles may have come from some combination of other people who, between them, have all the allele types in the suspect's profile. So even if this DNA profile is real, I'm not really sure yet because that statistic octillion should be a red flag to everybody. It's likely, and I think it should have been a DNA mixture because it is a party house for one. 2 victims were found in proximity to it, so their DNA should be on it as well. If a DNA sample had to be acquired going off experience, this would take weeks, months. Cops are at it. It's why they will not show the evidence, right? Because, yeah, it's either not his or they faked it. Yeah. So, again, I have yet to find a theory about something sound about how the DNA got there. Something sound about finding an accurate DNA profile. And it doesn't sound like they ever did any testing for female DNA. A female could have easily been involved, been the perpetrator. We don't know. There happened to be possibly, we don't even know if the roomies were there. But according to Payne, they were. But their DNA doesn't seem like it was tested to be, like they should have tested their DNA as well, just to see if it was in any areas that are alarming. May not have been, they may not have anything to do with it. I don't know, but that is important. So this is my favorite article because of the soup analogy. I think is a very good way to explain how transfer trace mixtures work. Now, I don't know if the DNA profile on the sheath is actually a mixture. I'm theorizing that it is, but we don't know. What's this?
Human nature is such that we have a tendency to seek out technological solutions. And sometimes in our drive and our excitement with the technological solution, we can sometimes lose the fundamental basis. About 15 years after the first use of DNA in forensic science, there was the realization that DNA could be transferred onto surfaces and detected. And that really spawned a whole industry and interest in seeing where we could detect DNA and how we could detect DNA, that may have lost sight of the fact that the DNA is not particular about where and when it transfers. And because the DNA is so powerful, this is in itself a risk, because everybody can become so excited about probing the technology that they forget that actually maybe this sample wasn't relevant at all. So we need to be particularly careful. This information is so powerful that we need to be really confident and careful and sure that it's relevant to the event that we're investigating. And because of that, it's my contention that what we should be doing with forensic science is looking at a coherent narrative. It shouldn't be that one sample in isolation solves a case. And in my experience, you asked me earlier on about my experience in forensic science, and I had a lot of dealings with our police investigators and with our prosecutors indeed. And maybe it's the same everywhere, but no sound prosecution is based on one finding, no matter how fantastic that finding is. We certainly shouldn't stop using DNA, one of the most powerful tools available to us in crime investigation. Maybe we need to pay more attention on a case basis rather than a sample basis, and to think of the totality of the case and the context of the case. Because we do need to mitigate these risks, but we couldn't possibly not get value from this amazing tool in crime investigation.
Okay. Take your time. Yeah, so they have censored my Twitter, so you have to click on this, because it won't show up back here. I'm always on Twitter on my phone, so I'm like kind of out of my element here when I'm trying to use it on my computer, because I want to find some of the articles. They don't have them there anymore. You're so funny. Okay. Where can I put it in here? How do I search my profile? I just have to go down. Okay, well, I was trying to look on my page, but it's taking too long. So I found this from the National Institute of Justice, STR Data Analysis and Interpretation for Forensic Analysts, Mixtures with Indistinguishable Contributors. I really think that if they did get a DNA profile, it should have been indistinguishable because of all the DNA and the people coming in and out of that house. So, items falling into this category include non-intimate samples such as swabs from windshield, sidewalk, floor, wall, weapon. This category applies to mixtures that are not included in the two categories described above. These mixtures are typically the most difficult category to interpret. In general, the interpretation of two-person mixtures, where each person donates half of the DNA, will not be aided by estimating percent contribution or percent peak height ratios. Applying statistical interpretation is more simplistic with one contributor, single source samples, or mixtures where a major component can be defined or inferred. Statistical evaluation of complex mixtures involves the use of the likelihood ratio or probability of inclusion-exclusion. Yes, so these are the two things that I think Bill Thompson is confusing. These two equations right here, which is causing it to be a fallacy. And it's such a well-known fallacy that there is a lot of psychological journals, lots of studies done on what's called the Prosecutor's fallacy. So that's this likelihood ratio and the probability of inclusion and exclusion. Now, some of the videos that I was watching earlier, I think I showed it, is that when prosecutors mix up fallacies or statistical equations and they try to make it look like if the DNA matches the defendant, then the defendant is guilty. But in actuality, sometimes those same statistics that the prosecutor is talking about actually are exculpatory and actually show that it is not a match, that it's not the defendant's DNA, but it's the way that it's worded and it's the way that it's presented by some of these experts where that it does get confused, which is absolutely amazing to me. Wait a minute. Did I find something else? I think I may have found something else for everybody. Let me see. Yes, I found it. Okay. So at the bottom of Becca Barlow's declaration, she included this called Inside the Cell, The Dark Side of Forensic DNA by Aaron E. Murphy. So it is curious why she included this in her declaration. The dangers of database cold hits and coincidental matches. In 2001, states had just begun to make major inroads in collecting DNA from known offenders and storing the profiles in DNA databases. Catherine Troyer worked as an analyst in the DNA unit of Arizona State's crime laboratory. At work one day, she received notice of something interesting. Two seemingly unrelated individuals, one white and one black, shared the same two markers at 9 of 13 places in the standard DNA profile. Indeed, they also shared one marker at the remaining 4 places of 26 possible genetic differences. They had 22 in common. Yet the 9 locus genetic profile should have been exceedingly rare. According to the standard means of computing the random match probability, if you plucked a non-Hispanic white person at random from the population, there would be only a 1 in 754 million chance of finding that profile. For African Americans, the number is 1 in 561 billion. And for Southwest Hispanics, 1 in 113 trillion. And yet, here in a database of just 65,493 people, it was appearing twice, and in people of different races. Importantly, at the time, one of the most popular testing kits for forensic DNA analysts came in 2 parts, a 9-locus kit and a 6-locus kit. Because the kits were expensive and conducting DNA analysis took up a lot of lab time, many analysts did not bother typing a full 13-locus profile in every case. Instead, they routinely did only half the tests, reporting 9 locus matches that quickly turned into defendants' convictions. Analysts also routinely wrote their reports. Oh, it's too big. Wrote in the reports and testified under oath that 9 and 10 locus matches were highly unusual and rarely seen. For instance, Howard Professor Frederick Bayer, an early champion of aggressive programs of forensic DNA typing, testified in one criminal case that he had only seen a 9-locus match between 2 people once. That was in a case of brothers. Intrigued by the prospect that such matches were in fact not uncommon, Troyer had 2 of her colleagues wrote up a quick summary of their findings and submitted the results to a major international conference on forensic DNA typing. Her observations came to the attention of Becca Barlow, a public defender in San Francisco. Barlow, a passionate attorney who held a master's degree in genetics along with her law degree, took immediate interest. As it happened, she was in the midst of defending a California man, John Puckett, accused of rape and murder from 30 years earlier. In 1972, nurse Diana Sylvester was found naked near her Christmas tree. She had been sexually assaulted and fatally stabbed. Police had collected forensic evidence, but DNA typing was still decades away. The case sat open until over 30 years later, investigators dusted off the badly degraded DNA samples and tested them. Running the results through the state database, a parcel match linked then 70-year-old wheelchair-bound John Puckett to the only testable evidence in the case. Sperm found on the body that showed reliable results at just 5.5 loci and possible results at another 1 places. On the basis of this match, prosecutors charged Puckett with murder. Barlow promptly contacted Troyer for more information, but Todd Griffith, the head of the lab, intervened and denied her request. Shut out. Barlow sought a subpoena from an Arizona court to compel the lab to disclose its findings. Barlow called Troyer to testify at a hearing to decide whether to grant the request. Troyer testified that she found not just one matching 9-locus pair, but 90 such paired matches. Whoa. When the lab offered no explanation for why 1 in a trillion events were happening regularly in Arizona database, the judge granted the subpoena. The order also included a directive to the lab to conduct a full search of the known offender database and report back all matching pairs. Ultimately, the report showed that there were actually a quite large number of these pairwise matches. The Arizona database only has 65,493 people in it, each identified by 2 markers at 13 places that constituted his or her supposed DNA profile, yet 122 sets of people shared the same genetic markers at 9 places of the 13. That's crazy. I have to sleep now. Oh, good night, Misty. So lovely to see you. I can't wait to talk to you soon. Wow, it's late over there, 1:30. Well, sleep well. Have a good night. And Twiz, yes, this is from Bicca Barlow's declaration. That is what we're reading here. Oh, see you soon, Misty. So 9 places of the 13, 20 pairs matched at 10 places. 1 pair matched at 11 places and 1 pair matched at 12 places. Only the 11 and 12 locus matches were confirmed siblings. Yeah, I think you're right. I think that our DNA is more similar than these forensic DNA people can convey to the jury or a jury. It is akin, no digits to represent birthday, bank account, and social security numbers all combined together, only to learn that a significant number of people share most of those numbers. There you go. She said it too, Twiz. And in the same order as you. As news of these unexpected pairings swept the nation, lawyers in other cities pressed for smaller searches. After all, if there were 122 pair, 9 locus matches, and roughly 65,000 person-sized database, how many matches might be found in 11 million person national database? A back-of-the-envelope calculation suggests the figure could be as high as 20,000, but rather than embrace the inequity of the FBI effectively instituted a crackdown, officials called Troyer's results misleading and meaningless and moved to suppress her findings. The FBI also used its power as the guardian of the national database to bully states into refusing to conduct similar studies in their own databases. Whoa! FBI leaders reprimanded the Arizona lab, claiming that disclosing the results violated its agreement with the FBI. They further threatened to cut off access to the national database to any lab that independently conducted their own studies, although there was evidence that the threat was intended to scare judges more than lab officials. Why Troyer's findings were so explosive? The answer turns half on an understanding of match and half on an understanding of law. And as is so often the case with forensic evidence, the gap between those worlds proved critical. Jeez. So I don't know if I'm going to go much longer here. Maybe just a few more. I really do want to read this all in one sitting. Yeah. Matches are called cold hits because they are associations prompted by genetic identity rather than unconventional investigative leads or information. Suppose a burglary occurs at home, crime scene analysis recovers some blood by a broken window, which they expect belongs to a burglar. They type the sample, yielding a 13 locus DNA profile. Analysts can enter that profile into a forensic index. There, the profile will be searched against. If there is a match, the submitting laboratories will be notified. They can in turn exchange pertinent identifying information, such as identifying a known offender whose profile matched that from Bloodwich from the broken window. These kind of hits are known as offender hits. Matches can be made between crime scene samples, otherwise known as forensic, scene-to-scene, or case-to-case hits. So suppose that the burglary occurs, but there is no match in the database to a known offender. The profile thus sits in the forensic database. Later, another burglary occurs across the state. The crime lab recovers evidence, obtains a DNA profile, and uploads that profile to the forensic database. Although there may still be a match to a known offender, the database will return a match to the earlier burglary. Now investigators know these two incidents are related and may be of a broader pattern of criminality by the same person. "12 hours or bus." That's what you did. Yeah. Oh. Well, you should do that again and have people call into your show. I don't have no one to come in here for 12 hours. Does anyone in the database match this evidence? Versus, does anyone in the database match anyone else? This second question is interesting. Does anyone in the database match anything else? Does anyone in the database match this evidence? Because this second sentence here, does anyone in the database match anyone else? It sounds like that sentence that Jacob Barlow was referencing in the pages above this one, where she's talking about the prosecutor's fallacy, where she says something like the probability of someone matching Brian's DNA. Now, that doesn't really say anything about a crime scene. That just says something about Brian's. But in the eyes of everybody, they're like, well, if they're talking about DNA, it has to be DNA at the crime scene. What if they're just talking about Brian's DNA? Like, period. There's no crime scene attached. Because we know how slick Bill Thompson is. Jeez. So, yeah, does anyone in the database match anyone else? So what are the odds that someone else matches Brian's DNA? I don't know. These are just the kind of things I think of when I see stuff like that. Anyway, explains why some forensic experts dismiss the Arizona findings as both expected and inconsequential. A sophisticated understanding of match statistics would have led anyone to expect some number of shared 9 locus pairs in the database, but a sophisticated appreciation of criminal trial practice explains why. Troyer's findings took criminal justice actors by surprise. Police, prosecutors, testifying lab analysts, and even some defense attorneys find it hard to believe, even infuriating, that 9 locus matches were likely to be common in large databases. In large database match. Even without clearly condemning evidence, because such matches were treated by lawyers and courts as conclusive proof of guilt. That's crazy. Troyer's findings also rekindled the debate about the accuracy of DNA statistics and led to a public call to allow qualified researchers access to the DNA database to test the validity of the assumptions of independence underlying match statistics. Over 40 scientists and academics signed onto a letter published in Science magazine calling for a range of real-world tests of propositions that previously have been addressed only by simulation. Granting such access was entirely in keeping with both law and practice. The law creating the national database specifically includes the provision for access if personally identifiable information is removed for a population statistics database for identification, research, and protocol development purposes, for quality control purposes, and in fact, the FBI has granted that access to researchers aligned with its interests. But given possible adverse findings, the FBI shut down all outside inquiries. Instead, the FBI claimed that the database was not representative of the general national population. It contained too many relatives at one extreme and wildly divergent population groups at the other extreme. As leading scientists at the FBI wrote, observed departures from expectations will occur using these databases accordingly, as they asserted 9, 10, 11, 12. It looks like there's not enough. Baker Barlow rightly pointed out there's not enough information known about these databases, that in these databases, there are connections that are being made that we don't quite understand yet. And it looks like there does need to be a study done to see why are these matches happening, where the science community has understood the way that these base pairs match in a certain way. They have understood how these databases are put together, how they're searched, and how they are applied to things outside the database. However, it looks like that information needs to be updated because now they're finding other elements that go against what was previously known. And it looks like the FBI has tried to shut that down anytime these labs wanted to do some sort of formal study on these databases. So, like, how is the average person or the juror going to understand? They're never going to know that there's problems with these databases. they're never going to know that they have run into things where these things are inexplicably matching. And so the information that we know as the public for how DNA works is in progress. It's like it's wrong because it's not the latest out there. Yeah, Misty's in Scotland. Yeah, I've met people from all over the world here. I don't know what it is, but I'm a magnet to Australians. Love it. They're hilarious. They're great. And apparently Australians don't put shrimp on a Barbie. I was kind of like, it's like my whole life just went, oh. They call them prawns for one, so there's no shrimp. And two, I don't think they grill them. So like shrimp on a Barbie was totally made up. But my whole life, that's what Australians do. But it's cute. It's fine. Oh, prawns. I think that, well, I've been reading a lot about research from the UK in particular and Australia. I think the Australians have chimed in too, but in the UK, they don't allow the use of IgG at all. Similar to like the laws that they've created in Maryland for the Montana and Utah, that because of these reasons, because it's so unreliable, because who knows how any of the DNA got in there? It doesn't just like you, and you don't have to like touch things. And so in the UK, they have the judge is more involved. They have like I think they have a whole hearing just to see if it's warranted that you could use it. Yep, our military doesn't use it, right? And in the UK, they have, it's already set up a part of their system. If you feel that you've been targeted because of your DNA, you can quickly get a civil attorney and you can sue the police officers that do that. And since it was so quick to find that information, that must be something that they do, because usually, I don't know, it must be something regular, or else like, why was it so frequent that kind of popped up in my searches? And in the UK, they're a little bit more protective of their information. Whereas here, I think we have like all of the cell phone companies or cell phone apps are taking all of our data and everything. So yeah, all these are funny. It's kind of funny. I like to hear about the outside looking in, like people from other countries that are looking at the things that we do all the time, and they have like a fresh perspective of it. And it's amazing how they could see this case for like what it is, where as Americans, some of us can't see it. Like they refuse to see. And it's not even like they've turned it into something that they like moral grandstanding. But the thing is, the U.S. judicial system is supposed to buffer of some of that. You got to think of some of the U.S. judicial system as a machine, and what matters is the information you put into it. So that's why they want everybody to be honest. They want you to sign, this is honest and true, the efficient affidavits, because the better information you put out, the better, or put into it, the better information you're going to get out. So you have to put in all of the right information, and the right information is there's no cell data. So we can't put that in the system if it's wrong. And so if you are putting in the system the things that the state has in this case, the system is going to be able to pick up that this person is innocent. Like the system is there to detect things like that. So, and it's supposed to buffer against this moral grandstanding. So, I mean, trusting the system a little bit, but we still have to put in the good information. I think I want to go for maybe another 10 minutes, and then I'm going to head out of here. But yeah. Interesting. I don't think I've read the bottom of this, surprisingly enough, but I didn't realize that the databases are showing, databases are more like a computer program. And as you know, I know in Epic that I work in every day, there's always something coming up that can be improved. They're always adding features. They're always fixing other things. They're always finding problems that, the code is running up against that's not working, that is like skewing our accounts or our numbers, or, it's not finding the accounts that we need. So not only could DNA be different or be similar, but also there could be inconsistencies in the database program itself, like its functionality. It might not technically be like malfunctioning, but these technology things. So instead of viewing the Arizona matches as an opportunity to refine and improve the criminal justice system's use of DNA evidence, the government chose instead to try to bury any data at odds with its interests. My God, they need studies done on the very DNA databases they're using. What's wrong with people? Indeed, that is what happened next to John Puckett's specific case. The prosecutor proposed to tell the jury that the random match probability, which was calculated as 1 in 1.1 million, partly in light of the Arizona findings, Barlow pressed the court to allow her to present the jury an alternative match statistic computed in her case to be 1 in 3. The statistic, commonly referred to as the database match probability, or DMP, aims to discount the impact of the match by factoring in the effect of a search in a database. In other words, it tries to account statistically for the difference between a truly random match and a match made among a finite pool of candidates. Barlow did not invent the DMP. Rather, it was put forward as the proper method by a blue ribbon panel of experts and what is considered the single most authoritative report on DNA evidence in criminal cases. The government contends that the database match statistic is misleading because it artificially deflates the match statistic based on the size of the database searched and does not account for the many ways in which a coincidental cold hit may be undermined. Such a match is failing to square the suspect in terms of sex, age, geography, but it is possible to take such information into account. And besides, it is unclear whether narrowing those demographics could unfairly incriminate swaths of innocent individuals. Most crime is committed by men within a certain defined age range and close to home. If sex, age, and geography are the way in which we differentiate a true match from a false one, those characteristics may be in many cases provided little safeguard against wrongful accusation. Amazingly, these two approaches were not only ways of representing the statistical significance of Puckett's match. Another method, sometimes called the Balding-Dunley approach, after its major proponents treated a search in a database as especially informative because a single match also constituted an exclusion of all of the other persons in the database. For instance, if a search in the 11 million person national database returns a match to only one individual, it signifies that attempts to match everyone else in the database failed. The net result can be a statistic even more inculpatory than obtained by using either database match or random match methods. Finally, still another approach, and probably the one most helpful to the jury, would have asked, of all the men who lived in the metropolitan area at one time of the killing and who were the right age to have committed the offense, how many would likely match the crime scene evidence? This approach, nicknamed the NP statistic by one of its proponents, helps place the match probability P in perspective. In Puckett's case, the result of such calculation was that at least 2 other people living in the area at the time matched the evidence. That is so crazy. Each of these statistics generates very different interpretations of significance of the match, yet all legitimate in one way or another, and there remains a lack of consensus as to which one deserves priority within the criminal justice system. A group of 25 renowned statisticians signed a joint letter stating they could all agree that the fact that a match was made through a database carries statistical meaning, even while acknowledging that they could not agree on a single method to express the significance of that match. Defense lawyers have argued that this disagreement among experts and the vastly different picture painted by varying approaches require courts to reject database match cases altogether. Alternatively, they have sought additional confirming testing, or at the very least presenting of conflicting statistics. Yet courts have rejected their entreaties for understandable reasons. Throwing out database cases too quickly disregards the value of cases that are made through a database match. At the same time, ignoring the conflict paints an unfair picture of uniformity and risks overstating the meaning of the match. Although presenting a bunch of different statistics may leave jurors in the awkward position of having to resolve among themselves a debate that even experienced statisticians cannot decide. Oh my gosh! It may be the best solution to an otherwise intraceable problem. The databases grow and cold hit searches continue. These questions become increasingly important. The determination by the FBI to move a 13 locus CODIS standard to a 20 plus locus standard is animated in part by recognition that advantageous hits may occur already. So the FBI wants to raise it from 13 to 20 plus because it indicates they already know the issue. After all, large U.S. databases continue to expand. A 2014 report by the European Network of Forensic Institutes spelled it out in plain language. DNA databases become larger. The chance of finding advantageous matches also increases, especially with partial and mixed profiles and DNA profiles of relatives, which have higher random match probabilities. The report gives the example of a DNA profile that a random match probability in 1 in a million 1 in 1 million. The mean result of a search such a profile in a 3 million person database is 3 matches, and none of them may be the actual originator of the crime-stained DNA profile, which since its inception has paid careful attention to advantageous or coincidental match problem recommendations that every DNA database manager determine the chance of finding advantageous matches in his or her database. To facilitate the process, ENFSI even provides a table of the likelihood of a coincidental match in particular size database given a particular profile's random match in a particular size database given a particular profile's random match probability, through the caveat that the calculations is complicated by the fact that far more than one crime scene profile is searched against the database each year. That is, the estimate must take into account not just the result of a single search of a profile against a large database, but a large number of searches against a large number of profiles in a database. For instance, as depicted in Table 7.1, when roughly 70,000 crime scene profiles of differing random match probability values are compared to a database with 4 million known persons, roughly the third the size of the national database. In light of the findings, SFI recommendations is twofold. First, acknowledging the risk of advantageous matches whenever database matches are found, it counsels expected number of advantageous matches when searching a DNA database of a given size with DNA profile giving random match probability. RMP crime scene related stain. Number of searches. Expected number of advantageous matches. What? Okay, so when you are searching a database, are they already expecting more than one person to match it? Like, what is this count? An expected number of advantageous matches. So I don't believe it's Brian's DNA, but even if it was and other people match it, that doesn't really mean much. It's so crazy. DNA databases contain large numbers of DNA profile known persons of biological traces related to unsolved crimes. When the number of DNA profiles in a DNA database increases, so does the chance of getting an advantageous match with a person who is not the actual donor of the trace. This is especially true for partial DNA profiles and mixed DNA profiles because the chance that they would match with a randomly chosen person is greater than the chance a full single DNA profile would match a randomly chosen person. If there are doubts if the matching person is the donor of the trace, for instance, because there is no other tactical or technical evidence which links the person to the crime, the possibility to do additional DNA tester can be considered. And didn't they say that? I remember reading that it was recommended that the Moscow PD do additional DNA testing or continue to look for a suspect. Yeah, I think they mentioned that in this document. Okay, so at this point, the attention particularly applies to matches which are found as a result of large-scale DNA profile comparisons. Yeah, so when you have a partial profile, it's going to match a lot of people because it's not full. And the fuller you get, the less the profile is going to match others. Second, the ENSFSI recommends that managers of DNA databases keep a record of the number of advantageous matches along with conditions under which they were found. Size of the database number searches for future analysts. ENSFI further advises a warning should be included when reporting a DNA database match. In contrast, Here in the United States, neither SWGDAM nor NDIS operational manual, the FBI DNA guidance documents discuss the problem, much less probability of the advantageous hits with any depth. The FBI's response to the issue continues to mirror its response to the revelations of the Arizona matches to truncate any questioning. The fact that only bad cold hits that come to light are those in which law enforcement seriously blunders. There are no public statistics on how many database hits generate an investigation that stalls before the suspects is notified or arrested. Instead, what comes to public attention are cases in which suspects are fortunate enough to have ironclad alibis. The first example of such mistake occurred in 2000 in the United Kingdom using 6-locus match. Police arrested a 49-year-old man by the name of Raymond Easton for burglary that occurred 200 miles away. One account placed the rarity of the profile as in 1 in 37 million. Trouble was, Easton was severely disabled by late-stage Parkinson's disease and thus was physically incapable of committing the crime. Additional testing eventually exonerated him. A similar case occurred in the United States when a woman in Chicago was arrested and charged with burglary based on DNA evidence found at the scene. Although the precise details have not been released, it seems that lab technicians communicated the match was a hit to police investigators when in fact it was only a partial match. So is allegedly Brian Koberger's. Partial matches, they don't tell you much. The error came to light only after the woman offered an indisputable alibi. She had been incarcerated on the day of the offense. Oh! Kind of like Lucas Anderson. He was under a physician's care. Like the doctor, it was in his medical record that Lucas was in the hospital. He probably had a bed number. And, the nurses who signed in on their shifts so that were assigned to him, they probably had the round sheet. Finally, another burglary prosecution, this one in Ohio, perhaps most directly illustrated the dangers of allowing misunderstood DNA evidence to overshadow what is known about the case. The owner of the home wrestled with an invader described as short, stout, and balding, and managed to grab a few hairs off his head. At a 6-locus profile with a random match probability of 1.6 million was entered into the database where it sat for years until a newly loaded offender profile returned to a match to Stephen Myers. Myers, a tall, slender man who would have been 15 at the time of the burglary, had no connection to the city, was indicted for the offense. Investigators waved away the physical discrepancy by noting that appearances change. What? Fortunately, the prosecutors assigned to the case began to have second thoughts and ordered further testing. Those results proved that Myers was not the burglar, and he was released from jail after 7 months awaiting trial. In other cases, false matches have been revealed by the perpetrators' failings to match the right demographics characteristics, which hardly proves strong reassurance that there are adequate safeguards against the rush to convict based on a cold hit. As for John Puckett, Bicca Barlow took his case to trial. Ultimately, it is hard to know whether Puckett was guilty of the offenses or not. On the other hand, no other evidence directly connected him to the crime. None of the many fingerprints found at the scene matched him. At the time of the incident, the sole eyewitness description had caused police to focus on a different man, but none of the original police investigators was able to testify given the passage of time. The man had escaped from a mental institution just before the murder and was suspected in 2 different sex offenses within a close radius of the victim's apartment. A drop of blood in the man's van had matched the victim. When Barlow requested that it be tested, it was missing from the evidence file. That man had died several years after the killing, so he could not be confronted. On the other hand, Puckett was the right age, gender, and race, and had been in the area at the time, all conditions that diminished the probability of a coincidental match. He mostly matched the description given by the sole eyewitness, who unfortunately had never been shown Puckett's picture and had died before trial. The jury also heard from 3 women whom Puckett had threatened with a weapon and sexually assaulted around the same time. The convictions had landed him in a database. Was Puckett rightly snared by genetic technologies that did not even exist at the time of his offense? Or had police found a coincidental database match, seen a record that fit, and assumed it must be him? Thanks to the judge's order, the jury heard only part of the story recounted here. The court excluded all evidence of the alternative suspect. Jurors were informed of the government's probability statistic that there was a 1 in 1 million chance that a person picked at random would match the crime scene DNA. They even heard another government expert claim that the right way to calculate the statistic would have asked, how many individuals do I have to examine before finding the one whose DNA would produce the profile seen? The crime scene evidence. By that matrix, the jury was again told that a relevant number was about 1 in 1.7 million. But although the jury was told the random match probability, it would never heard that Puckett had been picked as a result of a non-random trawl through a police database. The court excluded this evidence even after the jury sent a note during deliberations asking how Puckett became to be identified. Thus, the jurors were not equipped to contextualize the random match probability information in the context of a database search without information that the jurors would likely not understand what a profile considered rare. Had other evidence pointed to the defendant becomes less improbable when the defendant is found through a trawl in a large database. In short, if profiles probability is 1 in 1 million, then the government should expect a match if it looks for that profile in a 1 million database. The nature of these statistics tell us that the profile ought to appear whether that person committed the crime or not. Jurors also never heard about the Arizona matches and how they brought to light the fact that sharing alleles at 9 loci is not uncommon. They did not learn that even using the government's own probability statistic, around 40 other people in California matched the crime scene evidence, or that according to the database match statistic endorsed by the Bible of Forensic DNA, the National Research Council report, the probability of a match to database searched by the government was 1 in 3. They never learned that it was likely that 2 other people in the area also matched the same evidence. In the end, the jury convicted Puckett and was sentenced to life without parole. Since Puckett's case, every major court that has considered these questions of how to treat match probabilities in a cold hit case has rejected the idea that cases should stall until the scholarly community determines the right approach. Yep. However, most courts have also not taken the opposite track. The one absurdly enforced Puckett's trial court that only the random match probability should be introduced. Instead, courts have tended to treat the scientific validity of a statistic as a factual question for juries to resolve. allowing both sides to present whichever statistics they deem most favorable. But a handful of misguided courts continue to unjustly cabin the presentation of match statistics. One court even went so far as to declare that the means by which a particular person comes to be suspected of a crime is irrelevant to that person's guilt or innocence. Because the suspect is tested again to make the match, the court reasoned that the second test erases the effect of the database search. But in the words of one scholar, the court's theory is patently fallacious, an argument that later searches replicate the match from the trawl is not responsive to the concern that an initial trawl dilutes the probative value of the matching DNA. In other words, if you look in a database to find a redhead and do in fact find one, it means little to no confirmation that the redhead found does in fact have red hair. What matters is that you combed a database to find that characteristic. It's the difference between asking whether you'll pick a redhead if you open a yearbook and point randomly, or can find one in an entire graduating class. The problem of the database match statistics also points to something more fundamentally wrong in the way in which forensic evidence is used by the criminal justice system. The enthusiasm for technological solutions to enduring question of whodunit often outstrips the actual capacity of the technology. As unsatisfying as it feels, there may be cases in which the absence of other evidence inculpating the defendant counsels against giving undue credence to questionable evidence of a DNA match. But rather than admit that not all questions can be answered, the criminal justice system tends to embrace flawed techniques and gloss over genuine concerns about their responsible implementation. Unfortunately for John Puckett, there will be no further testing in his case. There will not even be vindication of his attorney's position, which later prevailed in California courts because Puckett died while his case was pending appeal. Besides all of the evidentiary samples that were taken, only one matched to him, and the test that was done consumed the entirety of the sample. Puckett's case exemplifies why simply retesting the evidence or testing more loci to achieve greater certainty about identity is often not feasible. Old evidence makes for bad verification material. The problem with cold hits is not likely to disappear. In fact, there is a reason to believe that there will only be more, not fewer, such cases going forward. The federal government has encouraged police departments to reopen old cases and to check for possible DNA evidence. And Congress has allocated funds in support. Advocates for sexual assault victims have pressed investigators to look through their troves of untested rape kits in search of possible evidence. These efforts should be applauded, but they should also proceed with caution. New technologies have vastly improved technicians' ability to wrest typable results from old and degraded samples, but those results are often more contestable than the profile gleaned from high-quality, well-preserved stain. Nonetheless, matches will be made in many cases. No other meaningful evidence will develop, and a jury or judge will be asked to decide whether a probabilistic statement of guilt, which may be more or less convincing depending on how it is presented, alone is enough for a conviction. These databases. Jeez. Oh, hello! We've got some visitors in here. Kane, hello. Welcome. Oh, Brian Koberger's in here. Hello. Welcome. Really dumb other me. Welcome. DoorDash driver. Welcome. Jack Showalter. Welcome. Plastic pants. Strange suspicious. Heavy hitter scientist guy. Welcome. Brenda. Welcome. Kane B2, welcome. Hello, everybody. Oh, I missed one. The cactus in the middle. Get out of the basement. Aw. Aw, Kane B gave me a hello. Well, that was all Abika Barlow's stuff at the bottom of her declaration, and it does sound like there are issues with the database, and I don't know what it is, but the police, James Bond, hello. The police have kind of just shut down. They're like fine with the way DNA and databases are defined now, and like they don't want it to change. And some of the public seems to think, well, the CSI way to find DNA evidence is fine and it should never change. But what we're finding is that DNA is changing. The way databases are used is changing. And the previous notions that we had of DNA and how to search for it are no longer. So I don't know how you can dispel things like that. I'm doing very well. How are you, James Bond? I have been shot out of a cannon. Hello. Keep reading before Twizzlestick starts talking again. How many do you have? Is that all the same person, Twiz? We have Brian Koberger and Jack Showalter in here too. What is going on? Kane has all those? That's the guy from Linda Lane? TikTok is live. Hello. Aw. Thank you for the little bump. That's crazy. Do we know if anybody else is going live tonight? Did this just in? Whoa, Lana says she's gonna go live at 10. So thank you all for coming. I am 12 Gauge is live, and Swamp Rose and Robert are going live like in an hour, I think. On Robert's channel. Robert. Well, that's great. That's great that they're all gonna go live. Is rubber the same as 12 gauge, or are they different? True Crime Cop. Oh yeah. He's good. That is so awesome. Thank you for hanging out today, Twiz. Yeah, I think I'm gonna relocate and then hop on one of their lives. Is it paranormal? Wow. Well, I hope both of you enjoy your weekend. I'll probably go live sometime tomorrow too. There's so many DNA articles to read. All right, well, I will catch you all maybe on a live later. So have a good weekend. Bye.